Hey, it's Ben. Rahul and I started this podcast because we love hanging out with fellow trial lawyers and sharing ideas that can make us all better. And both of our firms also regularly collaborate with other lawyers across the countries in cases where we can add value. If you're interested in collaboration, or even if you just have a case or an idea that you want to bounce off us or brainstorm, Rahul and I are going to be hosting confidential case workshops the first Wednesday of each month. So here's how it works. If you have a case or an idea that you want to talk about or brainstorm with us, just send me an email to ben@elawvate.net, ELAWVATE.net, or go online to elawvate.net and submit a case workshop request. We will schedule you for a confidential 30-minute Zoom meeting where we can talk about your case to see if we can help. If you feel like there would be good value in collaborating on the case further, we can talk about that. If not, that's okay too. We enjoy helping other trial lawyers because we know someday you'd be willing to do the same for us if we needed your help. So again, if you're interested in workshopping your case with us, just send an email to ben@elawvate.net or fill out a case workshop request at elawvate.net. And Rahul and I will look forward to chatting with you soon. Today's episode of Elawvate is brought to you by the Expert Institute. Rahul, you guys use Expert Institute, right?
We do use Expert Institute, and it's fantastic to get different experts in different fields, but the best of the best. And you don't know until you do the research, and they do that all for us.
Today's show is also brought to you by Filevine. Filevine has a platform called Lead Docket, which is the state-of-the-art way of tracking all of your intakes and leads, particularly if you're putting money into advertising. You don't want to waste money by missing a lead or missing a good case. It also doesn't mess up your case management software by keeping it in a different platform just focused on your leads. So check out Lead Docket by Filevine. Also brought to you today by Steno. Steno is a product you've used a lot, Rahul, right?
Steno is fantastic as a court reporting company. In addition to that, if you haven't tried Transcript Genius, it is an AI-based search engine where you can ask it questions such as, with an entire case, all the evidence on negligence, and it'll pull all the deposition testimony from all of the witnesses and put it together in a seamless way with hyperlinks to the actual text. Amazing.
And if your state law allows it, you can also defer the cost of depositions till the end of the case, which is, we were just going through our budget, and transcripts from depositions is in the top 5 of our expense items. So it's worth checking that out. Our show's also brought to you by Smart Advocate. That's the case management software we use at our firm. Our staff loves it. We love it. Very intuitive, very robust, can be adapted to do a lot of different things from mass torts down to small PI firms. So take a look at that. Finally, Hype Legal is the firm that we use for our social media and for our website design and development. We just rolled out our new website about 2 months ago that was designed by Micah and Tyler at Hype Legal. We love it. We've had a lot of great response to it. So if you want to see their work, come to our site at gideonason.com. And if you like what you see, contact Hype Legal and see if they could do the same for you.
Welcome to the Elawvate podcast. I'm Rahul Ravipudi.
I'm Ben Gideon. What's going on in your world out in Los Angeles, Rahul? It's been a little while.
You know, it's finally getting hot. I'll tell you that. So it feels like actual summertime here, which is fantastic.
Any fires?
But a lot of folks in trial over here too. Brian, Tom Schultz, and Alex Behar from our office are in trial down in San Diego. And then we got Jesse Creed in trial in Maui. So we've got a lot of things going on here work-wise too, which has been kind of fun.
Yeah, that's exciting. What are their cases that they're trying?
Brian, Tom, and Alex have a case involving a laborer who had to show up at a job site about 120 miles away the next day and caused a really bad accident, resulting in our client having a really bad leg injury, 18 surgeries, and ultimately is going to have an above the knee amputation. And so the big issue in the case was, is the employer vicariously liable for the employee's negligence? And they're saying no, we're saying yes, and I think it's going our way. And then of course, how much?
Well, good luck. I like your chances there. So we're in for a real treat today. We have three guests on: David Lebowitz, Doug Lieb, and Alyssa Isidoridy, who all practice law together and uh, do the kind of work that I think sometimes is considered to be the most challenging, but also the most important and rewarding, doing civil rights cases on behalf of people that have been affected by that. And also, I noticed you guys are wading into some of the kind of key issues that are going on today with the current change in our political climate and effect on people in this country. So thank you for the work that you do. I should also point out that unlike most of our guests, Rahul, these people are actually really smart. I think David, didn't you? Were you in my partner's law school class, or you know him from law school? Is that right?
I was, yes. I went to law school with Taylor. Fortunately for me and everyone else in our class. Yes. So that's our connection.
You, Taylor, and JD Vance, right?
No, JD Vance was in Doug's class, so I'm gonna let Doug take the credit for that. He was the year
Yeah.
below
Yeah,
us.
So
That's why you
Doug,
got the scruffy beard.
it's my responsibility. Yes, I had the beard first, actually, so I can take the blame for that one, certainly.
so Doug and David are graduates of the illustrious Yale Law School, and Alyssa, you're a slacker. You only went to NYU Law School, right?
I
So
know, I didn't even make it uptown to Columbia.
So, as I said, we have some really smart people on the show today, so we should probably just turn it over and let them do all the talking. But can you guys just talk a little bit about your practice? It seems like you have a really interesting, diverse practice, but focusing at least a good amount on plaintiff civil rights litigation.
Yeah, so we started our firm about 5 years ago. Doug and I and our partners, Ali Frick and Alana Kaufman. And we are, as you said, a litigation boutique with a civil rights focus. So we sometimes refer to ourselves as civil rights generalists, and by that we mean we sort of practice in the whole gamut of civil rights practice areas. So that includes employment and housing discrimination, educational discrimination cases, police misconduct, including wrongful convictions, false arrests, force cases. We represent prisoners and prisoners' rights cases, including conditions of confinement cases and medical care cases and force cases. We do some First Amendment work. We've done some voting rights work. We do disability rights work. So it's really a whole, basically anything you can think of that falls within the civil rights umbrella we sort of have our paws in. So it's very dynamic and interesting work, and no 2 days are the same. So it's very fun.
How did you get interested in this area of practice? And then how did you decide to cast such a wide net within it?
Yeah, well, so we before we started our firm, we all worked at another firm, an excellent firm, Emery Celli, that does similar work. That also had more of a commercial side practice as well. And I think we came to it from different origins and perspectives. I think, as some of us thought about, quote unquote impact litigation, right? Which is a term I personally don't like because most litigation has an impact, at least on the people whose lives it concerns. I was considering being a public defender. I don't know. And I think just through of happenstance, we all found our way to that area of practice at that firm and quickly discovered that it's fun to practice in a small firm environment that does public interest litigation and does civil rights cases because you get to deal with lots of different kinds of legal issues. You don't necessarily have to deal with some of the bureaucratic processes that are involved in sort of classic public interest organizational work. We like to say no, we don't believe in memos. Not because we don't believe in high quality thinking and legal research, but like, if you're researching something, you could just write it in the brief or you could put it in an email, right? And so we try to sort of bring the best of uh, business oriented practice in terms of being efficient and lean and nimble, but also, we're ultimately a mission driven organization, and we want to do this because we believe this area of law is important.
Well, Alyssa, how did you decide to get into this area of practice?
So I had always worked in nonprofits before law school, and during law school, centered my practice on immigrants' rights mainly, but in all different forms of advocacy. So policy advocacy, direct representation, and some impact litigation slash policy reform litigation. Um, and then I went to clerk, and after clerking, realized I loved the fast-paced nature of a docket that was always changing. And as David referenced earlier, because we are a generalist firm, I gravitated toward a place where I could get my hands in a lot of different types of cases. And some of it is short term, and we're able to resolve cases on behalf of folks pretty quickly, which is gratifying. And then we have longer term projects that allow me to get involved in different types of or different areas of the mechanics of litigation. So for me, it's a good balance of sort of every type of tool that's available in an attorney's arsenal.
So
Where
just
do you?
looking
Oh,
at, oh, sorry, go ahead, Ben.
no, you can go.
I am shamefully unfamiliar with the broad area of civil rights litigation in the way that you practice. So for someone as completely uninformed and didn't go to any Ivy League colleges like everybody here, what does it mean? And what are you able to do on a day-to-day basis to actually move the needle? Like, what part of this makes you proud? And if you're talking to someone to inspire them to get into your area of practice, how would you do that?
I'll take a crack at that one. Most of our cases are brought under federal statutes that provide remedies for people who have had their constitutional or other legal rights violated by government officials, right? So the thing that makes, just at the very basic level, when we're talking about civil rights, like there are plenty of rights that the law grants, but civil rights are, generally ones that are, under federal laws, sometimes state or municipal laws, and often against government defendants, right? So we're talking about people who have positions of power and then in one way or another abuse that power in a way that harms individuals, right? And so sometimes that harm is a physical harm, right? Like someone gets beat up by the cops. Sometimes or often that harm is a deprivation of liberty, a loss of freedom. Someone was convicted of something they didn't do, or wrongfully confined or detained for too long or something like that. And sometimes it's a harm to people's dignity, right? Like being discriminated against on the basis of your race or your gender identity or your religion, which also sometimes comes with real economic consequences if you lose a job as a result of that, right? So I think if you think about civil rights as a practice area, like what we're talking about is remedying abuses of power, but we also have certain specialized, ways of practicing, including that we're in federal court pretty much all the time, right? Because most civil rights are guaranteed by some federal law or another, which creates federal jurisdiction for the claims we bring. And being in federal court has its pluses and minuses. Jury pools tend to be a minus, right? Because you can't drill down on a particular county or whatever that you want the jury pool from. But the plus is the access to discovery, broad discovery. Federal discovery is really broad. And federal judges, like, you can get a hold of them if your adversary is like not complying with their discovery obligations, and they will like make them do that. And so the scope of discovery and the supervision of discovery are powerful tools for us as plaintiffs lawyers. And so, when we're looking at police misconduct, we're often diving into 10 years of similar instances of misconduct, right? And using federal discovery as sort of a tool to, build the case, and show potentially like a pattern of similar issues. So that's sort of like one unique aspect of how we do what a lot of lawyers do, which is hold people accountable for abuses of power.
What are you guys seeing right now for most of my lifetime, I've always thought of the federal government as the place where you go to vindicate civil rights, but it now seems like the government is in the process of trying to dismantle civil rights. And I'm curious what you're seeing in the current climate that's new and different.
Well, one thing that's definitely new and dismaying is the specific targeting of lawyers who, are perceived as having done work or pursued objectives that are counter to what the current administration perceives as the national interests or has characterized that way. So, law firms being targeted that have worked, on behalf of Democratic candidates or assisted with various, kinds of work that the current administration is displeased about. Stripping security clearances from lawyers, basically trying to nationalize certain law firms and dismantle their DEI and pro bono programs and, bring these firms to their knees to punish individual lawyers for, taking positions that are contrary to the current administration's policy goals. I mean, there was a recent filing in one of these cases defending one of these executive orders targeting a law firm on the ostensible basis that it had, taken dangerous actions to undermine national security. And in defending that statement, the government explained that it was referring to this law firm having provided support to and donated funds to GLAAD, the LGBT civil rights organization, which it described as trying to disrupt the US military through radical gender ideology. So, we're now living in a world where the federal government is targeting law firms as, basically enemies of state because they have supported LGBT civil rights organizations through charitable giving. So that's sort of in a nutshell, the environment that we're in right now, which is new and certainly scary.
How does anybody defend that type of approach? I mean, that's just ridiculous.
Yes, it is certainly ridiculous. I mean, I think that some folks in the administration perhaps realize that they had a problem the first time around, which was lawyers and courts that were really pesky, getting in the way of their ability to sort of accomplish their objectives unimpeded. And so they came in this time with a strategy to sort of preemptively neutralize that defense. And I think that's a bit what we're seeing now.
When you said they came in with a new
Oh,
strategy.
I think they came in prepared to aggressively, and affirmatively pursue these ways of basically trying to neuter the legal profession, basically trying to take control of law firms, dictate what clients they can represent, and, pull the chair out from under firms and lawyers who are, have the temerity to oppose them. And we'll see how effective that's going to turn out to be. But I think that's what we're in the middle of right now.
Do you have the DOJ or U.S. Attorney's Office involved in many of your cases, or are you generally dealing with private litigants?
So usually there's a subset of our cases that involve private defendants, which would be, employers, landlords, folks, defendants in a lot of the discrimination cases. And then in a lot of our cases against government officials or government actors, the defendants are at the state or local level. Occasionally, we will litigate against the federal government, either in a Federal Tort Claims Act context or Bivens, to the extent that still exists, which is minimal. But yeah, typically the government defendants that we sue are more frequently at the state or
State and
local
municipal.
level.
Yeah.
I mean, one difference that I certainly expect to see is we have in the past had, the U.S. Attorney's offices offer to support us, or, we have had cases where they've offered to file statements of interest in support of our positions in civil rights cases. That happened in one of my cases recently in the last few years in a case involving anti-gay bullying in a public school district. It's difficult to imagine the current Department of Justice making that kind of overture. So
The federal government has made it very hard to sue itself for damages. That is a bipartisan commitment, and in some respects a judiciary-wide commitment. And so that's the reason, in addition to the fact that there are just more state and local cops or governmental actors who interact with people at like a sort of day-to-day level. Since we're a private firm, most of our cases are seeking damages as opposed to injunctive relief. It's really hard to get damages against the federal government because it's made it hard, and there are two fairly limited pathways that David sort of just alluded to. And so, the main federal civil rights statute provides relief when your rights have been violated by a state or municipal actor, not by a federal actor. And so that's always been the case. And that one the current administration is not responsible for. And that's why, I think most private civil rights lawyers focus more of their efforts on state and local governments. But, Alyssa and I recently had a case involving the denial of medical care at a federal prison, right? Like that's an area where you actually can successfully sue the federal government. And so, we do it from time to time.
You guys just got a really great result in a case that I want to talk about in a minute. But before we get into that, can you just give us a sense for how you get your cases and what is your vetting process? Because having litigated a fair number of civil rights cases over my career, I know that making the wrong decision on the front end can be a very frustrating experience. And in every one of these cases, you're facing motions, probably summary judgment and so forth. So tell us about the different kinds of things you see, and what would if listeners are out there and they might have a civil rights case on the end of their desk and think, well, maybe I should call these guys and talk to them about it. What are you looking for in a case that you might take and move forward?
Well, Alyssa, you're on the front lines of this one. You want to take this one?
Yeah, so we get referrals, we get intakes, and our process is that we have a lovely paralegal, and they take initial calls with folks who come in and write into our office, maybe by email, or you can leave a voicemail, and then have a couple of discussions on the phone and see what the circumstances are, review any evidence, and then we talk about these cases at firm-wide meetings that we have twice weekly. So that's really an opportunity for the partners and the other associates to say, "Hey, have you thought about this? Or have you looked into this? Or what do the text messages say?" Um, and then it's really a group decision-making process. Is this something that we think is righteous? Is morally good? Is advancing justice? And is this something that we think is winnable? And those are the two metrics that um, we really seek to make sure are in line. And there's a bit of flexibility there, but that's really the process. And it's nice. It's collaborative, and we can sort of use our collective brain power to think about alternatives to make sure that we're making the right decision on a case.
Yeah, and I'll say, just since most of the folks listening are probably operate on like a 1/3 contingency model, or many of them probably do. Like the federal civil rights statutes and most of their state counterparts that I know of are fee shifting, right? And so the prevailing plaintiff, if you prevail at the end of the day, you're entitled to reasonable attorney's fees. And that enables us sometimes to take cases that would not otherwise be economically viable for a law firm as a business proposition if it was just a straight contingency, right? Because there's that promise of a reasonable attorney's fee at the end of the day if we win. But, so sometimes we'll have a case, I had one case that was really important to me that was about a teenager who was stopped for literally 60 seconds on the street, actually around the corner from my apartment where I used to live, who just plainclothes cops come out of the car, grab him, stop him, search his bag for no reason, and send him on his way with no explanation and no reasonable suspicion or probable cause, right? We took that case because it it was important to us, and because the existence of fee shifting allowed some ability for us to say, hey, we know that this was wrong, and so if we litigated this vigorously, we would get some fees at the end of the day, but the damages are super low, right? Because even unfortunately the law does not attach much value to the infliction of harm to the dignity of a 16-year-old Black teenager who gets stopped by the cops and harassed for 60 seconds for no reason. And so, you know, mostly what we're looking to do is find a way to, have damages. We think about how long was the wrongful detention, right? Like what are the injuries if it's a physical injury case, right? If it's a, employment discrimination matter, how long did the person work there, what was their income, what's the strength of the inference that their firing was discriminatory, what's their front pay loss, what's their back pay loss, sort of. We try and do the best damages assessment that we can sort of up front, in the way that I think most plaintiff side attorneys, I imagine, do, but with this sort of backstop built in that sometimes we can do something that's quote unquote small but righteous, with the hope and the promise that if we succeed, we'll get a reasonable attorney's fee at the end.
That's a good. I appreciate your description of that case kind of vignette. Can you just tell us maybe a brief description of some of the other kinds of things you've seen like that, where there's an important right at stake and you've been able to litigate it to successful outcome, or at least pursue it on behalf of somebody?
Sure. I mean, I think many, if not all of our cases from our perspective fit into that category. We have a range of different practice areas, as we mentioned before, a lot of which involve, in some ways, people who are particularly vulnerable to abuse or mistreatment and who may not be particularly well equipped to, defend themselves or stand up for themselves. So one area where I do a lot of work is in cases involving abuse and neglect of people with developmental and intellectual disabilities in residential settings. And often, my clients in those cases are the guardians of the legal guardians, who are usually a parent or a loved one, a sibling of somebody who is, in a long-term care setting where they, may be nonverbal, they require assistance with basically all of their activities of daily living. And unfortunately, abuse and neglect, physical abuse, neglect, and other kinds of mistreatment are unfortunately more common in those settings than they should be. In those cases can be challenging, if your client is nonverbal, not able to really reliably describe what happened or identify the people involved. And so it involves, a lot of really in-depth and careful fact investigation just to sort of get your liability ducks in a row, because you need to be able to show either some sort of negligent supervision or deliberate indifference on the part of the people running the program. Ideally you can identify and prove, who specifically perpetrated the abuse in these individual instances, but that can be very difficult. But so that's one area that comes to mind.
Can I ask you about that area? We do similar cases, but on kind of straightforward medical malpractice or nursing home abuse. We have one now involving a nonverbal client who was suffered abuse at a facility. But we don't think of are you pursuing those on federal statutes, like a disability claim, and I'm just curious as to why you take that approach, and does that give you advantages over kind of a straightforward tort approach to the case?
Sure. It depends on the case. So in New York State, these programs for developmentally disabled people are some of the programs, some residences are operated directly by the state agency that oversees the developmental disability program, and others are operated by private providers who are regulated and overseen by that agency. So for the ones that are state operated, it's sort of a straightforward calculus. These are government actors, and so you get all the sort of enhanced remedies, the fee shifting, all of that, the federal jurisdiction that you get by bringing, civil rights claims as part of your case. They're also in those cases, because these are typically not skilled nursing facilities, they're community-based group homes where, most of what's the care being provided is direct support. It's not, staffed by medical personnel for the most part. So there aren't, always professional misconduct claims to be brought. So even when we're litigating them against private providers, if we can often we'll bring a hostile housing environment claim under the Fair Housing Act, or its state and local analogs, or we'll bring ADA or Rehabilitation Act claims for disability discrimination if the facts support that, which again, that gives us, federal discovery, it gives us fee shifting, and it can be sort of a valuable additional tool in the arsenal.
But it's a good question, Ben, right? Like I think, what's that expression, like when you have a hammer, like when all you have is a hammer, everything looks like a nail, right? And I'd like to think that we're sort of flexible, creative minded folks, right? But like we're used to practicing in federal court and thinking of things as federal civil rights, like it's our job to literally make a federal case out of it, right? And so, sometimes I think our default way of operating is to, look for the fee shifting federal civil rights claim that gives you the leverage of attorney's fees and gets you into federal court. And, that works well for us. And I think in most situations, I would be like, why would you pass up that opportunity if it's there? But, from time to time, I wonder in the back of my mind, like, what if we just sort of did this the more sort of regular way, right? Like, what are the cases where that would be the better fit, right? And I think most of the time we make a considered judgment that that's not it. But yeah, every now and then I'm just sort of like, maybe this one should be in Bronx County, Supreme in New York. We call Supreme Court is actually the lowest court. It's the trial court. If you've watched Law and Order, you know that. But sometimes I'm like, maybe this one should just be in Bronx Supreme. But then you're 6 years into the case in Bronx Supreme and you have like 3 documents and you're like, oh no, that was a mistake. So
Yeah, interesting. We try to avoid federal court in most of our cases. I don't know about you, Rahul. I mean, there can be advantages in some cases, but we're afraid of it.
We had one case too in which we originally brought it in state court and then ended up filing a related action in federal court, in part because there were bars to recovery in cases not involving certain injuries that didn't exist for a federal claim. So in that case, bringing the federal claim gave us additional leverage and ended up being the right thing to do.
Do you have a single judgment rule on an issue like that if you bring the same case in state and federal court, or how does that work?
Yeah, I mean, you can't recover the same damages, right? So usually we end up bringing all the claims, both the state and federal law claims together in one case. In the case that Alyssa's talking about, we, didn't get to the point of, we were doing some procedural maneuvering around trying to move the claims that we had originally filed in state court into federal court. But so we never quite got to the point of figuring out exactly where that was going to end up because the case settled. But yes, generally speaking, I mean, there are some instances where you can bring companion cases in both state and federal court, and the remedies are not completely coextensive, and so you can pursue both. But if a fact finder says your compensatory damages for having your arm broken or getting a burn or being detained for X amount of time or being discriminated against is $100,000, that generally speaking is going to be preclusive on any other action, even if there is properly, concurrent jurisdiction for different claims.
Take your playbook to the next level by joining a legal network of all-stars at psrplaybook.com. psrplaybook.com is a free digital legal library created exclusively for plaintiff lawyers by the nationally recognized personal injury law firm of Panish Shea Ravipudi LLP, and features video content showcasing the tactics, strategies, and concepts implemented by some of the industry's most successful trial attorneys. PSRplaybook.com promotes learning, shared knowledge, collaboration, and best practices. Get in the game and see for yourself by joining our national network of plaintiff lawyers. Subscribe now at PSRplaybook.com and learn from the best.
So I know you guys recently got a really great result in a case that Taylor told me about. I don't remember the details of it, but can you guys share the story of that case with us?
Sure. It's a long story, but I'll try to give the brief version of it. So we represented, or continue to represent, and have represented for about going on 5 years now, a man named Ralph Birch, who was wrongfully convicted of a murder that happened in the town where he grew up when he was 18. And it took a few years for the police to build a shoddy case against him, but they eventually did that. He was arrested, convicted, and spent 30 years in prison before he was finally exonerated. His conviction was overturned by the Connecticut Supreme Court. This is a case in Connecticut. And eventually, after that, the charges against him were dismissed, and we came on to litigate his civil claims. And it's a complicated case because we sued a number of defendants, including a bunch of state police officials who were involved in putting together the case against him, including a bunch of fabricated evidence. We also sued the former director of the Connecticut State Crime Laboratory, who had fabricated a forensic serological test result. And then we also sued the town of New Milford, Connecticut, which is the town where this occurred, whose police force was also involved in the investigation. So we sued the town and a couple of the town police officers who were involved in putting this case together. And so it was a sort of sprawling multi-defendant case with lots of different claims and theories. It was, very extensively litigated through discovery and summary judgment. And then we actually ended up winning affirmative summary judgment against the state crime lab director, and that sort of catalyzed settlement discussions with the state of Connecticut on as to the claims involving the defendants from the state law enforcement officials. And we were able to settle those claims, and that was finally wrapped up last year. And then that left the claims against the town and the town defendants, which did not settle. They went up to the Second Circuit on an interlocutory appeal after losing summary judgment. We won that, and then we went to trial. So we tried that case in March, the three of us, and it was a tricky trial for various reasons. The claims that were left in the case were sort of not the claims that had been the focus of the case for most of the time we have been litigating it. Those claims were no longer part of the case because they had settled. And so we went to trial against one retired town detective, the estate of another former town detective who was deceased, and the town itself, which was in the case as a vicarious liability defendant. We had both civil rights claims under Section 1983 and negligence claims. And yeah, we tried it to verdict, and we were able to recover on one of the negligence claims against the deceased officer. And so that's in post-judgment motion territory right now. But yeah, we were able to put that together and get a verdict that, wasn't necessarily the best case scenario that we dreamed about, but we were very pleased to be able to get this case in front of a jury, and finally, after going on 40 years of our client being, having this monkey on his back, having a jury of his peers say he was innocent, what happened to him was wrong, and he was entitled to be compensated for it, I think was very powerful.
And just so we're not burying the lead here, what was your verdict?
Oh yeah, sorry. So the verdict was for $5.7 million. We were also in the fortunate position of having served during the litigation an offer of compromise, which was a procedure that was allowed by Connecticut law, where if we made this offer and the town rejected it, which they did, then we would be entitled to 8% annual simple interest on any judgment in our favor exceeding the amount of the offer from the date of the filing of the complaint through to the judgment. So that ended up adding close to $2 million of additional interest on top of the $5.7 million verdict. So the final judgment was something in the order of $7.6 something million.
Then to the jury during closing argument, what were some of the points that you were making to illustrate the impact and harm to your client that you believe resonated with the jury?
Yeah, that's our client's name is Ralph, but he goes by Ricky. Ricky was an extraordinary witness and an extraordinary advocate for himself and has always been. He's just like a really, really bright guy who is just has an incredible memory of, very specific harrowing experiences that he went through in prison, right down to the just he can very effectively explain who was standing where and what they were doing in the yard at the time when this act of violence, broke out, right? And so I think in that sense, he was the damages case, right? It was really just his testimony, but he was the last plaintiff's witness, and there was a pretty abbreviated defense case, and so I think in some respects, that work was done through his words, right? But what we tried to do was just sort of, I think, have people keep in mind like both the you can say, prison for 30 years, prison for 30 years, but like that, the more you say that, in some respects, I think that kind of numbs the impact of like what it actually involves, right? So what we tried to do, and I think this is a strategy that, other folks who have tried wrongful conviction compensation cases have also adopted to good effect, is like spend a little bit of time in the testimony and then in the closing just talking about like what is actually involved in a day in the life in prison, right? Like, when do you get up, right? What is it like to get up in prison, in terms of the fact that, are you in a cell, are you in a dormitory, who is in your cell, what measures do you have to take in order to assure your personal security as soon as you wake up, which basically means they essentially unlock the door to your cell. And if you don't want to immediately get up and get out, you better go back and lock that door so no one else barges into your cell and assaults you, right? Where do you use the bathroom, right? Like, in your cell, where's the other person in your cell while you're using the bathroom? Like, try and, on the one hand, break down in sort of pretty considerable detail for the members of the jury, like what is actually involved in living in prison, so that they can sort of try and understand the way in which that really, number one, like involves no privacy and no dignity, but also is just like, it's incredibly boring, right? And it's an incredible sort of like waste of the sort of human talent of this person that I think they can see was like a bright, self-reflective person who had a lot to sort of offer. So that was like trying to keep in mind, on the one hand, that, and then the other hand, the sort of like extraordinary aspects of being incarcerated, right? Which involve, truly depraved acts of violence perpetrated by and against people you care about in your presence, that you hear, that you see, that you smell, right? And sort of all of the just like really horrible things that are part of our prison system in this country, unfortunately. And I think we're even more acute back because like this happened a long time ago, right? And I think things are still not good, but there's probably less violence, at least in the Connecticut prison system now, than there was, in the early 1990s, for example. And so it was trying to sort of get the jurors to keep in mind at once, both of those aspects of what he went through, and then of course all of the things he missed in his life, while he was wrongfully incarcerated for all that time. And so, you know, I know I could feel that it resonated with some folks. I think, I read the verdict as essentially a compromise verdict between some camps of jurors, and I'm sure I'm sure there were some folks with whom it probably didn't resonate. But I suspect that wasn't because they didn't empathize with their client, but rather because they, just weren't persuaded that these particular defendants were central players in the wrongdoing that occurred. And yeah, that happens. So.
What was the primary argument by the defense? I mean, I just like this whole glad comment where they're attacking I don't understand how you could defend a wrongful conviction where somebody's been in jail for 30 years.
Yeah, so the defense made some, interesting tactical choices. They really did not choose to, suggest that this was really a rightful conviction, or like, really rebut, in a meaningful way, I would say, our showing of innocence, right? The thrust of the defense was that, the conduct of these individuals was not the cause of the wrongful conviction. And I think that argument sort of had a couple of different forms, right? One was the sort of like, this was really a state police case. The town had this very minor role, which I think was probably how I would have defended the case if I were assigned to have done that. Then there was sort of a bit of a stronger form of that argument, which was basically like, these police officers didn't do anything wrong. And to the extent that there was a wrongful conviction, it was sort of the fault of the witnesses who said the false things, as opposed to the police officers who suggested that they say them. I don't know that that one landed as well as the sort of, allocation of fault among the defendants thrust. But it's interesting. We do a fair number of these cases, and if I were a defense lawyer, I would always, my approach would be like, we are so sorry that this happened. Like, if this person truly is innocent, like, that's a tragedy. Unfortunately, the criminal justice system is a human process. And like, even when human beings are trying their best, they make mistakes, right? And like, mistakes may have been made in the situation, and we're so sorry that mistakes might have been made, but it was not but it didn't meet the elements, right? I have yet to encounter that that defense approach, like, in the wild. And I don't know why that is. I think it's just because, in part, like, police officers have a sort of particular narrative and approach to these things, and it's frequently adopted by their counsel, which is sort of like, doesn't lean in as much as I think would be effective to sort of good faith mistake as essentially the defense. But so I'm still waiting for the first good faith mistake defense in one of these wrongful conviction cases, but I hope I never see it. So it's okay.
What were the turning points at trial, do you think?
I think so. The claim that we ended up prevailing on was a claim involving a town officer who went with there was a state police detective who had been a defendant but was settled out of the case, who was the main investigating officer. And basically, the way they were finally able to get the charges against our client to stick after years of investigation was by ginning up this statement from a jailhouse snitch who had known our client, who claimed that our client confessed to him. And the interview in which they got this initial statement from this jailhouse informant was recorded and transcribed, and it was led by the state police detective, but there was a town detective who went with him. And in the statement, you can clearly see the guy, I mean, it's clear as day the guy is making this up. I mean, he gets all the details about the crime wrong. He doesn't know anything. He gives a bunch of information that doesn't match what the police think they know about the crime. He thinks it happened during the day when it happened at night. He says that our client acted alone when it was known to the police that there were at least two perpetrators, et cetera, et cetera. And during this interview, this state police detective keeps trying, like, less and less subtly to coach and lead this informant as it goes on, because he's clearly frustrated that he's trying to pin this on our client. He hasn't been able to for 2+ years. And then in this recorded interview, he finally just says, okay, well, I have to be honest with you, half of what you're saying is wrong. So I'm just going to tell you how it really happened. And he just feeds him all these details about the crime that this guy didn't know, which the guy later incorporates into his statements and testifies to, as though they came from our client's supposed confession, which obviously never happened. And I think a turning point in the case, and what we know the jury thought was maybe the most important part, because they asked about it in their notes during deliberations, was during Doug's cross of the state police detective, who's the only living witness who actually came to the trial to testify about what happened during that interview. Where he just tried to say, I never fed him any information. I didn't do anything wrong. I played it totally by the book, and I thought he was telling the truth. And this was like an elderly guy. He couldn't hear that well. He kept asking to have questions repeated. But when Doug impeached him with his video recorded deposition testimony, where he had admitted that you're not supposed to feed information to witnesses, and where he says, this guy lied a lot and basically I knew he was lying, that really hit the jury. And they asked to have the clips, the impeachment clips of the deposition played back during deliberations, which we imagine was probably an effort by, the plaintiff jurors to bring over some defense holdouts or a defense holdout. That I think was one of the most effective moments in the trial, and Doug's closing, which was just phenomenal and kind of undeniable.
Well, it's an extraordinary case, and there's nothing sadder than a wrongful conviction where, like you said, somebody spends the only life they have without having liberties or freedoms or being able to live a normal life. I'm just curious, because it sounds like there were so many bad actors here and kind of a broad spread conspiracy to fabricate evidence and to achieve this conviction. Was there ever a motive ascribed for that or adduced through the investigation that occurred?
I mean, this is my. I mean, the answer to that is not strictly speaking, but I think my sort of hypothesis in general about these cases is that, like, most of the time it's an ends justify the means approach, right? Like, in my personal opinion, it happens in these cases that police officers intentionally falsify evidence to get someone that they believe inaccurately is guilty, right? Like, and so I can't really, there was no demonstrable sort of there was a meeting where they decided that, they were gonna put this, this lead detective who David was describing, I believe genuinely, in fact, to a point of maniacal obsession, believed that our client and his co-defendant, were in fact the perpetrators. That belief was insane, right? It was blinded to a huge body of evidence that made quite clear, even at the time, that they were not responsible. But I think he genuinely believed, and still genuinely believes, despite all evidence to the contrary, that they did it. And decided, in service of the goal of, quote unquote, protecting the community from people who we actually believe were the perpetrators, to break the rules, to, make a case against them because he couldn't do it by any other means. That's my reading of the situation, right? And I think, there's a phenomenon called tunnel vision, which is, documented in sort of research about police investigations, right? Where, like, the mind focuses on one particular person. You start reading all the available evidence through the prism of, oh, I think that person did it. Everything then starts reinforcing that belief. But then if you don't have enough, that's when corners start being cut and, statements start being given to people. And so, that's my personal opinion. But
What's been life for your client like after getting out of prison?
Yeah, I mean, it's certainly always a challenging adjustment, but he worked really hard, was employed right away. He's married, he's sort of doing doing a great job of, you know, maximizing the amount of time that he has to spend as a free person, right? And so, I think it's very common for folks in this situation to like just want to get away a little bit, right? Like there's a desire to just sort of, I want to find a place that's quiet, right? And sort of have a way to not live in the kind of stressful environment that reminds me of the stressful environment that I was forced into. And so, I think that's like a common experience that a lot of wrongfully incarcerated and perhaps even rightfully incarcerated folks have after they come out, right? Is like wanting to just find a little bit of peace, right? And I think that's been a major goal of his. But so it's everybody who goes through this experience would feel a serious adjustment process, right? And he talked about that in his testimony at trial and how difficult that was in some respects. But on the whole, I think it's a huge success story and a credit to him.
Just on the investigating officer having tunnel vision and your hypothesis on this, do you wonder how many other people he had tunnel vision with in in making sure they get convicted?
During the course of this investigation, he actually interviewed this like one alternative suspect in this case, right? This guy named Martin. And the lead detective goes to Martin, he asks him some questions, and Martin goes like, "No, I didn't do this. Like, I haven't shot anyone since like a few days before Christmas Eve in 1967 when I was on 128th Street off of Lenox Avenue and I shot that guy in the head with a Beretta." And the detective just sort of goes like, "Oh, okay." And he sort of like dutifully types that up in his report. And he's like, "But back to Ricky Birch." Like, and this comment just sort of like, this appears to be like a fairly detailed confession to this other homicide that occurred in New York City on like a specific date in a specific place with a specific weapon for which this person, Martin, was definitely not convicted. And there's this moment where I'm like, are you listening to what this guy's saying? Like, do
Do
you
do you want to
realize?
call someone about
Yeah,
this
like,
maybe?
you want to call the NYPD? And it's just like, nope. And so it's not exactly what you're asking about, right? But it does show to the degree to which his mental energy was focused sort of very solely on this question of like, how do I prove that, Ralph Birch and Sean Henning perpetrated this particular crime, and just like no interest in anything beyond that. And I've had this like pet project, like I tried to foil, that's the New York Freedom of Information law, like, freedom of information request to the New York coroner, because I'm just like trying to figure out if there actually was a homicide shortly before Christmas Eve in 1967 on 128th Street. And if so, whether someone else did it or someone else was convicted of it and it was really Martin, but I haven't been able to figure that out. So the short answer is yes, because there's a lot that he did not seem to be paying attention to.
Well, Doug, I know you have to jump, and we really appreciate you guys coming on and talking about the work you do. It's really important work, and congratulations on all the great results, and particularly in that case, it's really, your client is very deserving, that says, to say the least. I don't think anyone would trade money for the time lost, but you got him some justice there. It's
Amazing.
important, yeah.
And we got to have you guys back and then talk about how this new administration has really screwed up the justice system in all the different ways. I'm fascinated to hear your perspective on all of that. But thank you for coming.
Thank you guys
Thanks
so
so
much
much
for
for
having
having me.
us. It's been
Thanks
great.
so much.